Welcome to the Probate Nation. We're in the midst of a series of shows about durable financial powers of attorney. As we've discussed in those prior shows, a power of attorney is a disability planning tool recommended by estate planners to avoid the cost of a court-supervised conservatorship. But that lack of court oversight sometimes results in intentional and unintentional misuses of the power of attorney. The initial show identified some of the common abuses of this disability planning document. A subsequent show detailed some of the remedies available to address those very abuses. Powerful information and advice was shared in those shows by experienced attorneys John Keith, Ann Heisman, Steve Cochran, and Dave Bateman. I encourage anyone named in or currently using a power of attorney for a loved one to view those shows so you understand what you should and should not do. Our show this evening takes the discussion to the next stage. How is a dispute over your use of the power of attorney going to be resolved? What are the options? How long will it take to resolve the matter? All good questions. And to help us answer these questions and others, we are pleased to have as our guests tonight two retired Virginia Circuit Court judges who have seen such disputes play out in their courtroom and in recent years in alternative dispute forums such as mediation and arbitration. Our first guest previously served on the Arlington County Juvenile and Domestic Relations Court for 7 years and then served on the Arlington County Circuit Court for an additional 14 years. Since retiring from the bench in 2012, she has devoted her professional time to alternative dispute resolution with the McGammon Group, a private mediation and arbitration service. Our second guest served on the Fairfax County Juvenile and Domestic Relations Court for 17 years and then served an additional 8 years on the Fairfax County Circuit Court. From July 2017 to the summer of 2018, he participated in the Virginia Supreme Court Judicial Settlement Conference Program, and in July of 2018 he joined Juridical Solutions, a private mediation and arbitration service. Each of our guests has presided over numerous fiduciary disputes while serving on the Virginia Circuit Court and continue to do so now as a mediator and arbitrator. Please welcome retired judges Joanne Alper and David Schell. Guys, thanks very much for coming.
Happy to be here.
Happy to have all this great judicial experience sitting in front of me, or next to me. Well, Judge Schell, I see that you were very active for a while with the Special Virginia Program, Judicial Settlement Conference Program. Tell me a little bit about that program.
It's a program supported by the Virginia Supreme Court as a public service. It uses and utilizes retired circuit court judges who receive 24 hours of training in mediation and then 12 hours of special training from the Virginia Supreme Court on how to conduct judicial settlement conferences. It's offered free of charge to the citizens of Virginia, and there's no charge to the attorneys either. And it's a program that's been in place for over 10 years and is utilized throughout the state.
It sounds like an amazing program. Again, it doesn't cost anything, though I know we've talked about how it's important to have lawyers be involved to help get the matter organized appropriately. So why do folks participate in that program?
Well, it offers them an opportunity to have a retired circuit court judge who has a lot of experience in these matters to advise them and their attorneys as to the best way to resolve the circumstances they're in without having to go to court. It removes the attorney's fees that are required when you go to court, also the time and effort that it takes to go to court. Also, many times you have expert witness fees. All of that's removed if you're able to resolve it by one of these conferences, and these conferences do end up with a written settlement that is legally enforceable.
If they come to an agreement. Now, why do you think? I know we've talked about this. Why do you think the parties should be represented by counsel?
Well, these are important decisions, and they need to know what the status of the law is. They also need to know what their attorney's advice is as to the facts of their particular case, because every case is different, and without that legal guidance from the attorneys, I feel that they're at a real disadvantage, and it's important that both parties have an attorney, in my opinion.
Now, how are the judges, the retired judges, compensated for their service?
It's a flat fee, $250 per conference.
That is amazing to get all that expertise. And that's paid for by the state, though.
That is paid for by the state.
Does not cost the participants anything.
Nothing.
That's really amazing. Now, when I was doing some research about this particular program, I talked to the folks down at the Virginia Supreme Court, and I guess there's a very high success rate with this program. They do settle a lot of cases. Is that true?
That is true. I think the rate throughout the states, 60 to 65% of the conferences do reach a settlement.
Now, I understand that you're kind of quite the star about that program. I understand you have a very high percentage rate.
I've been quite fortunate. My percentage rate is 82%.
That's fantastic. That's fantastic. So if the parties do agree they want to take advantage of the program and they want to, how long does it take to get the process going?
It depends on the jurisdiction, but I would say you could get to a conference in 1 to 2 months in most jurisdictions.
Okay.
Would be in the normal time frame.
Okay.
Now, it does require a circuit court judge to sign an order referring the case to the program, and it requires a case to be filed in the circuit court. So if there's no case pending in the circuit court, you cannot take advantage of the program.
Well, that's important to know. So it's not as if you can just sign up for the program and try to solve the problem before you actually invest the time to actually file your case.
Right.
So we need
there
to get
has
the
to be a
facts out.
pending circuit court case. It cannot be a juvenile court case. It must be a circuit court case.
Okay, but we have to file the case. Well, moving from that really a very fantastic program. Judge Alpert, let's talk a little bit about private mediation. What is mediation?
Mediation is a process whereby parties and their counsel come together with an experienced, trained mediator. Many of our mediators are retired circuit court judges like I am. Others are just lawyers in private practice who are also trained as mediators. But the parties and their lawyers come together for a session. Sometimes the session can take all day into the night. Sometimes it's over a number of days, however long it takes. But go through and have discussions both collectively and individually with the goal of getting to the same place that the judicial program talked about, which is getting to a settlement of the case by an agreement.
Sure. Now, what are some of the advantages of mediation?
The advantages of mediation are, and let me first contrast it with the judicial settlement program. You can go to mediation at any time. It's not necessary that a case be filed. If you have people who are in the early stages of a dispute and don't want to let it escalate to litigation, they can go into mediation. You can get to a mediation session fairly quickly. I mean, depending on who the lawyers want to be their mediator or what their timing is, you can schedule something, at least in my experience, within a couple of weeks. The lawyers also get to select their mediator, so they can look at the list of mediators who are available and make a determination, because not every mediator necessarily is right for every case. The lawyers have to make a judgment as to whether the personality and the way that mediator works will be effective with their clients. So those are things that make mediation very effective in getting people together. And just as with the judicial settlement process, the goal of a mediation is to come up with a signed settlement agreement resolving the disputes between the parties.
Okay. Now, Judge Schell, let's turn back to you, though. How does the mediation that Judge Alpert described differ from the program that you were involved, that's the state-sponsored program?
Well, normally, with private mediation, your mediator is going to stay there until the agreement is signed. Every I is dotted and every T is crossed, and the mediator will be there the whole way to help people through. Because you can reach a basic settlement, but when you get around to putting it down on paper, additional problems can arise.
It's amazing how that details start to get in the way.
So in private mediation, your mediator will be there till the end. In judicial settlement conferences, occasionally a judge will stay to the end for those, but many times they'll get to the point where there's a meeting of the minds, and then their duties ends and the attorneys go about drafting the agreement. So that's one advantage of private mediation. Of course, the other one is no case has to be filed, and you don't have to have an order from a judge in order to take advantage of mediation. So those are the primary differences, and it gives, of course, the cost
course.
is major difference.
Now, Judge Alper, focusing on conflicts that arise with the use of financial powers of attorney, which we see more and more these days, how is mediation helpful in resolving those types of, what are typically, frankly, family disputes?
I think that mediation is one of the best ways to resolve those disputes for a number of reasons. Number one, you try to get the matter resolved before people are going to court and lobbing accusations. You can bring the ward, the person for who signed the power of attorney, make them involved in a way that's not threatening or requiring them to go and testify. Mediation doesn't involve everybody sitting in one room and just arguing across a table. You know, you have a joint session where everyone understands the backgrounds and parameters of the mediation, and then you go into separate rooms and the mediator walks between the rooms and gets the information in confidence from all the parties. So you can the mediator can become sensitive both before the mediation and in your preparation for the mediation and on the day of mediation to the issues that come up. And some of these issues, especially if you're dealing with siblings and families or dealing with, or with a parent and child, these issues really, the focus may be the power of attorney, but what they're really arguing about and what's motivating some of the emotion and the conflict is what happened ages ago when they were younger or whatever. And if a mediator can sense those, you can try to get through those issues to get to a resolution. Often it's just a matter of, you know, wanting to have everyone understand what's going on and there not being any secrets involved. And especially for the ward, and I've talked to people after doing these, both as a judge and as a mediator, the elderly person for whom everyone is supposedly interested is so much more grateful when they can come together and work things out than when they have to be dragged into court. No parent generally wants to be up there taking the side or testifying, dealing with one versus the other. The other benefit in family law cases, or any case, whether it's this case or family law cases, you can be creative in your results. You can come up with a resolution of the issues that is far beyond what the statute and jurisdiction of a judge sitting in a courtroom could do. You can address issues that aren't necessarily issues in the legal fight over the power of attorney, but are definitely issues within the family that need to be resolved. And mediation, as Judge Schell mentioned about the judicial settlement process, in mediation we have a tremendous success rate as well. Our group, the numbers we have for 2017, 87% of the cases that came to our mediators, and those are all cases in Virginia, Maryland, and DC, 87% settled at mediation or as a result of mediation, which means people are motivated. They want to come together and get it resolved. They have differences in how the case should be resolved, but that's what the mediation process is there for. And it is far more humane for all parties to do that in that setting rather than a courtroom.
Well, I think there's a lot to be said for that. I think it's a very, very powerful argument to be made for mediation. But let's turn to the next step, Judge Alper, is talk about arbitration. Okay, so what is arbitration?
Arbitration is, I guess the best way to describe it is almost like having a private court proceeding. And a person who's chosen to be an arbitrator sits and hears the evidence like they would if they were a judge sitting in a courtroom and make a decision. And that decision is a binding order. And interestingly enough, unlike a court decision, most arbitrations, depending on the agreement, but most arbitrations are not appealable. So that order is the decision and that ends the matter. So in that case, it's much more like a court proceeding. The difference is the lawyers get to pick their arbitrator, so it's not like you just walk into courtroom and you find out which judge you're getting. Obviously, you have to pay for the arbitration, which you don't in a court proceeding, but you get to a resolution far quicker because you can set your arbitration date. You're not subject to the dockets of a court that might not have a trial date for you till a year in advance. So you can get a quicker resolution, and it's private, which means that you're not sitting in a public courtroom in Arlington or Fairfax or Prince William or anywhere else where anybody can wander in and hear what's going on in your family. You're in a conference room somewhere, or even could be using a courtroom depending, but it's private, and you manage to keep that much of family things personal and private.
So the one difference then that I think the negative about arbitration compared to mediation is that the judge really can't step in and say, well, here's how we think it would really play out? Is that something you got? Both of you have mentioned that that's a big issue. You can't really, talk about what you think about the case.
When you're in a mediation, you're allowed as a mediator to be facilitative, to try to help people to get to a decision, but and you can talk about your opinion if someone asks you, what do you think that might happen? You can discuss that, but you have to be very careful, because we can't be in the position of being predictors of what a judge would do, what a jury would do. We can talk about our own experience. Gee, in my experience, never saw that happen before. Or you can tell a party, the judge in Virginia doesn't have the legal or jurisdictional authority to do what you're asking, or things like that. But you have to be very careful as a mediator not to basically coerce parties by giving your opinion. Oh, the judge said that, so we have to do it, because that's not we're not there as a judge. And you also don't want to interfere and be giving legal advice, because that's the job of the lawyer.
Sure.
So you have to sort of walk a line. In arbitration, you ultimately hear all the evidence, and you make a ruling just as you would if you were on the bench.
Sure. Okay. A little bit less interactive with the arbitration. Well, let's talk, Judge Shell, let's talk for a second about the benefits. We've been talking, sort of hitting different points as we go through this discussion. The benefits of the alternative dispute resolutions in the context of trying to sort out disputes that arise with the financial power of attorney as the families will get ready to go to war, over different things. What are some of the advantages that you want to bring out?
Well, if you mediate the case and reach a resolution, nobody has to get on the stand under oath in an open public courtroom and say things about the other members of the family that cannot be taken back.
We want to stop for a second and emphasize that can be something that you regret for years to come.
These proceedings in court, when individuals testify under oath, can tear a family apart for generations. So we definitely want to avoid that. Secondly, as the judge has mentioned, it's incredibly difficult on the ward to go to court. Many times their children are fighting, and they're not in a position anymore intellectually to deal with that, and it's difficult for them. So mediation removes that. Also, mediation is cost effective in the larger cases because it removes the need to go to court for attorney's fees, expert witness fees, and time away from work. So those are three of the major issues.
Judge Alper, how about you? Some things you want to add to that?
I agree, but I would also add, I think having the ability to get to a resolution process sooner rather than later is helpful. The longer these issues go on, and the parties are back in court with motions and arguments, and you're not going to have a trial for 6 or 9 months away, the more money is being spent for lawyers and for expert witnesses, and the more the relationship among the family members, the parties, are deteriorating. And so if you can get into a mediation and get something done more quickly, you're cutting down on the cost, you're cutting down on the emotional expense, and I think it's a far better way rather than letting this thing fester. For sometimes some of our courts are backed up for 6 to 9 months or a year to be able to get a trial date.
Well, let's switch gears. We are actually starting to get close to the clock here, running out of time. There's so much to talk about. We don't do the judicial settlement program. We're not doing mediation, arbitration. So the last venue is the court is to actually go through a formal trial. So there's two choices. Basically, there's a trial with the jury. So how often do we see those, Judge Alper?
I was a circuit court judge in Arlington for 14 years. I never saw a case like this go to a jury trial. And there are reasons for that. Lawyers are entitled to ask for a jury in most of these cases. The problem with a jury is that they don't understand a lot of the kinds of issues that we're dealing with, and that they'll get legal instructions, but they're sometimes much more complex than an instruction in a car accident case or in a criminal case or things of that nature. And secondly, you tend to have to be even more limited in the evidence you can let the jury hear. a judge, even though the rules of evidence are the same, sometimes a judge can hear a little more of what's going on and try to fashion something within the jurisdiction of the court that can help in resolving the case. A jury, it's a, here's who we find for. But I think the fact that juries are not the best triers of these kinds of cases is an indication of why I never saw one. I don't think any of my colleagues in Arlington saw any during the period I was on the bench.
Okay. Judge Schell, how about yourself? So we go from the jury trial to the bench trial. So you've sat in Fairfax for many, many years. Talk a little bit about the bench trial.
I have never had a jury trial on these types of cases either. I've had numerous bench trials, and the bench trial does have some advantages. If you have one or two people who just will not settle, will not resolve the case, and are in the judgment of the other siblings unreasonable, a bench trial can settle that problem. The judge will hear the case and make the decision. Also, if you have a highly technical case with some very unique and challenging legal arguments, a judge can resolve those legal arguments and reach a resolution, so hopefully the family can go on from there. So there are some advantages in those circumstances.
Okay. Well, both of you practiced law before you went on the bench, okay, and then you've been on the bench for a number of years, and now you've moved off into the private world of mediation and arbitration. You've seen the whole gamut of all the bad things that can happen and the good things. Disputes over financial powers of attorney, what's a good course of action to get these matters resolved?
I think, in my opinion, the best course of action is to get someone involved early on to try to cut through, someone who's not an advocate for any of the parties. Sometimes the person that brings it to a head is a guardian ad litem for the ward who is appointed by the court and who's saying, wait a minute, we can't be doing these things. We can't be fighting over these things. You're harming the ward. You're expending his or her assets for uses that they can't ever get back. But in my opinion, the main thing is to whoever's got the power of attorney in the first place, to be transparent. The biggest issues happen when one sibling or one party thinks the other is doing something nefarious, doing something underhanded, self-dealing. Oftentimes, those suspicions are unfounded, but the only way you find that out is by actually looking at the documents and talking about it. So transparency and openness, I think, helps avoid a lot of what we've been talking about this afternoon.
Okay. Judge Schell, how about yourself? Anything, your thoughts about how to get these
Yes,
cases?
I totally agree with transparency. I also think access to the ward is very important. If you're the person taking care of the ward, make sure the other siblings have an opportunity to see that person on a regular basis. And also, if you change the status quo without letting everyone else know, you could end up in court. For instance, if you take the ward to an attorney and change the will, giving all of the property to you, and the other siblings get a small amount, and you do that without notice to anyone else, that's a recipe for going to court. So transparency, access, and maintaining the status quo probably will keep you out of court. If you're the one running the checkbook, balance it every month and let everyone else see what you're spending the money for.
Well, those are all good suggestions. Well, we're really getting close to the end of our show. I wanted to give an opportunity for each of you to share some final comments, briefly if you could, about what you would recommend, a couple points you want to make about this whole process and how we can resolve these disputes without spending a fortune out of the ward's money. Judge Alper?
I think the first thing is to avoid disputes arising by following Judge Schell's advice, which is being transparent. Don't make moves of the ward without notifying everyone else. Make sure that everything you're doing, you would be happy to have a court or some independent forensic accountant look at it and say, this is all perfectly fine. Absent that, I think getting away, looking to resolve the case, firstly, in the very early times is the best thing. If you wait and say, I want to have my day in court, you've lost. Because by the time you have your day in court, the emotions and the money are all spent.
Judge Schell, anything you want to add?
If you're the person taking care of the ward, and God bless you for being the one who takes care of them 24 hours a day, maybe 7 days a week. Be cognizant of the fact that the other beneficiaries or siblings need to know what's happening and treat them with respect. If you're not the person taking care of the ward, be thankful that you have a family member who's doing it, and be respectful of them, and understand that they're under pressures. They're the one who are there at 3 a.m. in the morning when things go wrong. So treat the other person the way you would like to be treated, and I think you can resolve the issues.
Well, Judge Alper, Judge Schell, I want to thank you so very much for taking the time and sitting with us and sharing your vast experience on this very, very difficult topic, which is at the forefront of a lot of the litigation we're seeing nowadays. It's great service to the folks in Northern Virginia, and we want to thank you again for coming in.
It's my pleasure.
My pleasure.
Thank you. Our guests shared with us the various ways to resolve these disputes that arise through the use of a financial power of attorney. Non-binding mediation, either through the Virginia Supreme Court Judicial Settlement Conference Program or through a private mediation service, is often the least expensive for all involved and the most informal and expeditious approach. The retired judge who typically serves as a mediator can share their unbiased assessment of the case, and that can be helpful in getting past the emotions of the parties and focusing on what is best for the loved one everyone is trying to help and protect. Alternatively, binding arbitration can be beneficial, though it is more formal than mediation. And as a last resort, formal litigation with either a jury or bench trial is available. Regardless of the approach selected, I urge all family members involved in a dispute over the use of a power of attorney for a loved one to get advice from an experienced attorney. That independent advice will be well worth the cost incurred. This brings us to the conclusion of our show this evening. I hope you found it informative. And remember that replays of the show can be viewed on the Probate Nation website. On behalf of the Probate Nation, thank you for visiting with us.